Hi, everyone. Harry here to talk about a preliminary injunction entered by a judge in Rhode Island, Judge McConnell, in a lawsuit that 20 states brought to challenge the United States Department of Transportation for adopting this condition on federal transportation grants. That's big chunks of money that the states get, often under the spending clause, which is a power that Congress has under Article 1 to condition certain grants on the compliance with some conditions by the states. For example, a 65 mile per hour speed limit. That's a classic. We'll give you these transportation grants, but you have to, in return, have a speed limit no higher than that. That the court has held. We have in recent weeks been talking about things that the government can't just do willy-nilly and impose on the states. It's different if they're acting under the spending clause. All right. So Department of Transportation, purporting to act under the spending clause, says if you want these transportation grants, you have to cooperate with federal officials in the enforcement of federal immigration law. I love this order because what it basically concedes is that absent some kind of additional authority like the spending clause, it's not required for states to quote unquote cooperate with federal officials in the enforcement of federal immigration law. We've talked about this in the context of other lawsuits, and I have written about this in my Substack with a fairly pointy-headed piece last week about the 10th Amendment. But as I pointed out there, the federal government is saying anytime the states stand up or, in the state's view, fail to cooperate, for example, not letting them go around them to arrest people, the feds are very aggressively coming in, arresting people, claiming that they are impeding or even obstructing federal law enforcement. Something like this is an implicit concession that that ain't really right. There are things that the federal government is interpreting as obstruction with federal law that I think courts and implicitly Department of Transportation, others within the administration understand might really be better construed as failure to cooperate. And we know under 10th Amendment law, the courts and the Supreme Court in particular are very strict about that principle. And if the feds are trying to get the states just to lift their little finger or pass any laws or whatever, the courts have come in, the Supreme Court especially, with alacrity to say, oh, no, you can't do that. Now, that was law that was established and reinforced and again reinforced in the last 20 years, ending about 10 years ago. And it's going to be very interesting to see how the court adapts it or construes it in upcoming cases. As I point out in that Substack, there are just now states that are tumbling to this idea that what's really happening is a violation of the 10th Amendment. That was one of the two claims that California makes against the feds in saying you can't just federalize the National Guard. I've suggested, though it hasn't been brought up in any lawsuit, that all these cases in which we know that ICE is relying on, wants to actually arrest people in state court because they know that the immigrants there will have gone through magnetometers on their way to court appearances, which they're making dutifully, by the way, only to find themselves grabbed by the collar and sent who knows where. That strikes me as something the state can say, no, people come into this courthouse for official court state business. That doesn't include your taking advantage of it to facilitate your arrest. Something like that, it seems, could work out. Also, There are different sanctuary cities that are being challenged now by the feds, but they could push back on this general theme and say, you're calling this interfering with you guys, but actually it's just refusal to cooperate. Think about the arrest. This is of a federal official by a Fed, so it's not the same principle, but it illustrates it well, of Congresswoman MacGyver, I think it is. And, there's this whole scrum and everyone's pushing on everybody. Is that ICE kind of really being overbearing toward her, or is she, as they've alleged, assaulting them? So you can't assault, true, but you can't be forced to cooperate. Anyway, that's the principle in play, and the fact that DOT is moving has imposed this whole spending clause requirement, to me, is a concession that they understand, the administration understands it is weak here. Okay, moreover, Judge McConnell grants this preliminary injunction yesterday in a really forceful opinion. It now, of course, as always, has to run the gauntlet of appeal. This would be the First Circuit, potentially the Supreme Court. But let me just go through what McConnell says. First, there were two ways in which the administration said, hey, you're in the wrong court. The states need to bring this either in the claims court or the courts of appeals based on special congressional enactments. And McConnell says, no, that's not the way it works with this claim. Then he goes through we're now all familiar with this 4-part test of whether to grant preliminary relief, which is not the same as striking something down, but since it incorporates as its first factor likelihood of success on the merits, it's really deeply related. And here's what McConnell basically says. Hey, DOT, you can't do this. Congress could maybe try with its spending power, but they haven't, and Congress hasn't granted the Department of Transportation any power to, as he puts it, conscript, that has sort of great 10th Amendment resonance, to conscript the state government into federal immigration enforcement efforts. So we have a 4-part challenge by these 20 states. Ultra vires, you have to get the power from Congress and you haven't. Violation of spending clause. You violated the APA because you violated the spending clause and you didn't have any entitlement to do it. And then finally, there are different constitutional provisions and principles, including the spending clause, in violation of the APA. So what McConnell says is basically the states are likely to succeed on the merits of some or all of their claims. It's so slightly funky, right? You normally would think he would go through the winner and sort of point it out. But instead, he, on this all-important likelihood of success, says, some of these are definitely going to fly. And the big point he's making that he is holding is you don't have the administration, once again, is weeding in Congress's garden. You don't have authority to use the spending clause, which is a paradigmatic power of Congress under Article 1. Congress allocates and spends money to try to push around the states. And at that point, he marches through the irreparable harm, the balance of the equities and public interest, all of which he finds are in favor of the states, the 20 plaintiffs, who would be irreparably injured if all of a sudden they were pressed into service to do these things that the feds are asking that would really trench on their sovereign interests. So, strong statement on preliminary injunction granted, and the whole kind of context of the litigation is a little bit of a blink from the administration about all these things they are asserting so kind of pugnaciously states can't do. Appeals to come, of course, but it's a strong statement that, it serves as the new status quo. Forget about these regs for now, DOT, and it will go up now to the First Circuit, presumably. That's a pretty progressive circuit. And just in general, the basic point here, but the spending clause is something Congress does, not something the administration does. Strikes me as very solid and uncontroversial. So we'll see what happens. But the general pushback on this whole sort of stance of the administration, get out of our way, you're impeding our efforts, and the actual ruling on spending clause is, that's a favorable development that I think is likely to hold at least at the First Circuit level. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.